I would like to focus on the question of the relationship between democracy and liberalism by focusing on the institutional, on institutions of democracy. And I would like to look at particularly the Israeli case. There are two phenomena that I think should be examined in that, especially the relations between two central phenomena in recent times. The first one is judicial empowerment. It's not a new phenomena. It's or not completely new. It's known around most democracies during the last at least three decades. That is the rise in power and centrality and political centrality of high courts, high judicial institutions. And the other one is the phenomenon that is discussed here is of democratic backsliding or democratic decay, or it has several names, or constitutional regression. And my aim is to examine the relationship between these two phenomena. The question is if and to what extent and how these relatively recent processes of democratic backsliding are related to judicial empowerment. So firstly, it's fairly clear that there's hardly a doubt that in various systems, democratic backsliding is characterized, among other things, by the attack on the status and integrity of high judicial institutions. That happens in Poland, Hungary, and Turkey, and probably in other jurisdictions as well. Secondly, both judicial empowerment and democratic backsliding are both connected to one major process in liberal democracies, and this is the rise of executive power at the account, I think, of parliamentary sovereignty. So let's say a few words about the decline of parliaments. The decline of parliamentary power and the erosion of executive accountability to parliament has been documented in many systems, mostly but not exclusively in parliamentary systems. It is the result of various factors such as executive dominance over parliaments through the whip of party system, significant centralization of power in the office of prime ministers, the lack of second independent and powerful second legislative chamber, and most importantly, the rise of the administrative state, especially outside the confines of traditional government departments and by shifting power to quasi-autonomous agencies. As the result, courts are pushed into the center of the stage as the principal mechanism to check administrative and executive power. So, the above process of parliamentary decline explained a few things about the relationship between judicial empowerment and democratic backsliding. It explained why courts in liberal democracies became the principal mechanism to review over governmental power, but also why constitutional court became the main target for populist leaders within the process of democratic backsliding, and also how within the process of executive and political control over parliaments, this process served as a useful vehicle for such executive leaders to crack on judicial institutions and to curtail their autonomy and powers. Now, I would like to, this was the general background for me to discuss the Israeli case. And I would like to discuss the question whether we can see democratic backsliding as at least partly a reaction to judicial empowerment while discussing the Israel, or on the basis of discussing the Israeli case. And if you look at the Israeli case, I think it comes to mind that the relationship between democratic judicial empowerment and democratic backsliding is perhaps a bit more subtle. And we can look at democratic backsliding as sort of reaction against judicial empowerment. Now, there's a caveat here. I don't argue that the Israeli case is representative or even typical in that respect. In fact, I suspect that the Israeli case is somewhat atypical, but nevertheless, I think it is interesting because it tells us something about the relationship between courts and democratic backsliding in general. A few words about what is known as or discussed in the literature as the rise of judicial power in Israel. For those who are not acquainted to these materials, until the 1980s, the Israeli Supreme Court functioned as a sort of typical high judicial institution within the general pattern of common law jurisdictions. As of 1980, however, the court initiated several moves to extend its grip over bureaucratic and executive system, including a number of moves like scrapping doctrines that limited access to judicial review, such as standing and justiciability, expanding the scope of review over the reasonableness, not only the strict legality of executive power, expanding state liability in various fields, including, for example, tort liability of governmental agencies and so forth. Now, the expansion of judicial power was conspicuous with relation to the political system. And that included allowing interest groups, political parties, and MKs to petition the court on almost every subject, expanding judicial review over parliamentary internal procedures and internal party processes, expanding judicial review over the legal apparatus of the government, in particular prosecutorial decisions and advisory opinions of the Attorney General, thus effectively conducting a takeover over the legal apparatus of the government, and extended judicial supervision over political and executive appointment and removal. This is particularly important for my presentation, by developing a principle known as the principle of good character. Actually, the word in Hebrew is tohar midot. I don't know what is exactly the right translation for this term. Few words about the principle of good character. It states that any governmental appointment should stand the judicially introduced standard of good character. It was developed by the Supreme Court as of the early 90s as a general common law principle that is not on the basis, not in accordance actually to statutory law, but on the basis of the reasonableness doctrine. It enables the court to step in and block any appointment and order removal of any public officials involved or suspected of involvement in any type of scandal, financial, sexual, and so forth. And in fact, it constitutes a unique process of impeachment by judicial review. So just for our Israeli colleagues, there's nothing like it all over the world. So there's no other system, legal system in the world where you can go by a regular process of administrative review in court and remove from office any officer, political, military, or executive. In all other systems that I know of, this is done by complicated and complex impeachment processes, which are usually composed of a combination of political and judicial elements. But here in Israel, as it was developed by the court, it is considered to be purely a legal question, and it can be conducted by a regular process of judicial/administrative review. Now, what was the effects of the good character principle on the political arena in Israel? The court removed and blocked appointments of several high-ranked executive officials, military officers, ministers, and deputy ministers. Just one example, in 2015, all three senior appointments in the Israeli security forces, that is the chief of staff, the police commissioner, and the prisoner service commander, all these appointments were compromised by legal processes, and actually the people who were finally appointed to this position, all three of them, were not the original appointees that were made by the government. And another consequence of this is that criminal complaints and the initiation of criminal investigation as a vehicle to interfere in governmental appointment became almost a standard procedure. In Israel, for example, all last 6 prime ministers in Israel have been subject to some kind of criminal investigation. Few things about the internal logics of the good character principle. The court main rationale for the implementation of the principle is protecting public trust, or the trust of the public in the political system. This is the official rationale in judicial rhetoric. And this means that the court, despite being the least democratically accountable branch, purports to bolster the presumed democratic trust of the public in its representatives. This came to a serious question in a case, in 2013 case known as the Three Mayor case. Chief Justice Grun is sitting here with us. He was one of the justices on the bench, and the situation. And the situation and the scenario was the following: you have 3 incumbent mayors that are serving for a couple of years as mayors, and there were prolonging investigation against this police investigation. But 3 weeks before the municipal election, the Attorney General decided to proceed and to indict these 3 incumbents, and there's immediately a petition to the High Court of Justice to remove them. Now, the justices on the bench, they know the following, that they can remove these 3 mayors as mayors immediately, but they cannot prevent these 3 mayors from putting the name on the ballots in the upcoming election. And they also knew that these 3 mayors are very likely to be re-elected in 3 weeks, just to be removed again by the court after the re-election. Which, by the way, they were all 3 elected, and you see, and the court has to speak about public trust in its representative, and you see some of the justices, such as the deputy Chief Justice Justice Rubinstein, asking how can we talk about public trust in these 3 mayors, where, as an empirical conjuncture, if these three mayors are going to be re-elected in 3 weeks, who are we representing here? But nevertheless, the court did remove the 3 mayors they were all three elected and then removed in other procedures again. So what are the effects of all this on the legal system? The incentive involvement of the judicial system in politics brought about the politicization of the judicial system. The legal system at large, and the court in particular, envisaged a sharp decline in level of public trust and support in opinion polls. The court is no longer enjoying the status of consensual, politically neutral, public servant type of institution, rather as an ideologically motivated player within the public arena. Hence, not surprisingly, the court became an easy target for political populists and as a necessary target for those politicians who face criminal position, such as the current Prime Minister of Israel. Now, and at the same time, for Israeli liberals, the Supreme Court and the judicial integrity manifested by the good Cartesian principle became the main political platform. That is, it is the only, actually, if you look at the upcoming third round of election, it is the only meaningful political agenda that unites them all. That is, the political arena in Israel is currently divided into two main parties, the anti-court party and the pro-court party, with all other pressing ideological and policy agendas set aside. So if we were, the study of courts and the function of courts in democracies was, first we had courts as just manifesting the governmental power, then we had courts as perhaps 150 years ago, beginning to be some kind of institution that check on administrative power and then check on constitutional power. We now face, I think, a new stage in Israel. That is the phase of a court as a representing institution, a politically representing institution. For Israeli right-wingers, the judiciary serves as the ultimate target for their attacks on liberal democracy. But for Israeli liberals, the court has long stopped serving as just an ancillary mechanism that is designed to enforce the rules of constitutional framework, or even as the referee of the democratic game, and not even the constitutional defender of human rights or minority groups as developed in the second half of the 20th century. Rather, the court currently serves as the main part of their agenda. For them, the court is actually representing democracy as they know it. They expect nothing from the regular majoritarian political process. For them, free elections are no more than necessary but unpleasant and hopeless technical move, something like visiting the dentist once a year. All their visions and hopes are concentrated on the judicial apparatus. So to sum up, Israel is currently divided between one camp that for its members, democracy is nothing but general elections and majoritarian rule, and the other camp, democracy seems to be everything but representative government, elected by equal ordinary elections. Arguably, the role of the judiciary in this process that brought about this state of affairs was far from being passive, and rather it is the incentive process of judicial empowerment that served as a background for development of democratic backsliding as we view it today in Israel. Thank you very much.